This is the matter of Daniel Richard versus Sherman Packard and Chuck Morse. I believe we have Mr. Richard on. Mr. Richard, can you hear me? I think you're muted.
There we go. Can you hear me now?
I can, yes. And I believe we also have Attorney Cianci and Attorney Lehman appearing on behalf of the Speaker and Senate President.
Yes, sir. Richard Lehman here for Senate President Chuck Morse.
Good afternoon, Your Honor. James Cianci on behalf of Sherman Packard, Speaker of the House.
Thank you. And I see that we have a number of other people on. I'm just going to ask that if you are not either Mr. Richard or one of the other counsel who just identify themselves, if you could make sure that you're muted so that we're able to conduct the hearing. I'm sure I will have some questions for both sides. I have some questions for both sides here. But when I first hear from the defendants, then I'll hear from Mr. Richard. And I should let counsel know, and Mr. Richard, that I have reviewed both the motion, the memo of law, and Mr. Richard's memorandum in objection to the motion to dismiss. And I have reviewed the cases cited by everyone in support of their respective positions, as well as the constitutional provisions and statutes relied on. So I don't know if Attorney Lehman, Attorney Cianci, who wants to go first?
If it's okay, Your Honor, I think I'll go first and then stop halfway through, and Mr. Cianci will pick up if that's okay with you.
Absolutely, absolutely.
Okay, thank you very much. This really comes down to 2 questions, Judge, and that is, one, whether Part 1, Article 32 creates a mandatory obligation on the legislature to take certain actions in response to petitions or remonstrances filed under Part 1, Article 32, and 2, if it doesn't, whether the court is going to use judicial authority in an effort to compel the legislature to do something that's not constitutionally required. I know you've read the relevant provision from the Constitution, but I do think it's worth reviewing quickly. Part 1, Article 32 says, "The people have a right in an orderly and peaceable manner to assemble and consult upon the common good, give instructions to their representatives, and to request of the legislative body, by way of petition or remonstrance, redress of the wrongs done them and the grievances they suffer." I would submit, Your Honor, that there's nothing in there that creates a positive right in a citizen to force the legislature to take any action whatsoever. That provision provides substantive protections that are very important. It says the people may peaceably assemble. When they're doing that, the police or soldiers are not going to come and break up their meeting where they're talking about things that are of importance to them. That's an important substantive right, and they're right there in the amendment. They are allowed to give instructions to their representatives. They're allowed to say what's on their mind, what they want their elected representatives in the general court to do. Although it's not written into the Constitution expressly, it's always been understood that the people will not be retaliated against by the government based on the requests that they may make of their elected representatives. And they may describe, as they want to, the grievances they have and the steps that they want their elected representatives to take to redress those grievances. In New Hampshire, I don't think it's constitutionally required, but we've done it this way here for a very long time, unlike other states. Any member of the House of Representatives or any member of the Senate can introduce a bill about any topic, the only restriction being that senators are not allowed to introduce money bills. Every bill gets assigned to a committee by practice, and every bill that gets assigned to a committee has a hearing, a public hearing. In most other states, a representative who files a bill doesn't have a guarantee that his or her bill is gonna get a public hearing. The chairman of a committee can do a desk veto just by never calling assigning it to a committee. We don't do that here. When we do assign a bill to a committee, anybody can come off the street and testify, and it leads to some interesting testimony, but we think it's worth it. And finally, every bill that gets introduced, no bills get killed in committee. They all make their way to the floor, and they all get a final vote by the one body or the other. So we do more to permit citizens to address their grievances than just about any other state I can think of. Now, Mr. Richard he's obviously a bright man. He's done some obvious research. He's put a lot into his claim, and I congratulate him for that, but I would submit, Your Honor, that quite simply, the constitutional provision that he relies on doesn't compel the legislature to do anything with a remonstrance or petition that gets filed. There's simply no next step in the Constitution. He's protected from retaliation. He can file another one tomorrow. Well, probably not tomorrow, but Monday. There's nothing stopping him, and he makes no claim that anybody's tried to stop him from filing. The part of his claim has to do with the action taken by the legislature in response to his filing, and the Constitution simply requires no specific response whatsoever.
Let me ask about what you said. What is the process from your perspective by which the legislature complies with its obligations under Part 1, Article 32, with regards to remonstrances? How does the legislature meet its obligations under the Constitution?
By not retaliating against somebody who files a remonstrance. I don't think that there's a requirement that the legislature engage in an act of formally accepting a piece of paper. A petition can be addressed to the legislature, it can be delivered to the legislature, it can be left at the House, but there's no obligation that it be filed away in any particular way. There's no obligation that it be recognized formally. It is simply Mr. Richards and every other citizen's right to address their concerns to the legislature, and I would submit that by addressing them to the legislature, that doesn't mean necessarily in the mail. It means speaking to them, whether through the press, whether through any other means of communication. By having a rally on the State House lawn, but not necessarily to have a document get filed away in a way that he thinks is appropriate, because that would be an affirmative requirement placed on the legislature, and there isn't one in here, and there is a corresponding constitutional provision to balance against this, and that is the provisions that state that each house shall make their own rules of proceeding. Those are very important constitutional provisions. The House and Senate each are fully authorized to make rules that are consistent with the Constitution. Nothing in any of the House rules is inconsistent with a constitutional requirement, unless you find, as Mr. Richard would like you to find, that there's an affirmative duty to do something with his petition or remonstrance. And again, I respectfully submit there is none.
I do have one other question about the Part 1, Article 32, and that is, Mr. Richard makes a point that in the motion to dismiss, there seems to be a suggestion that there are no greater rights afforded under Part 1, Article 32 than are afforded under the First Amendment, the U.S. Constitution. Do you agree with that?
They're co-extensive, in my view.
Thank you. I'm sorry, I interrupted you. Please, I don't know if you had anything further.
I would rather answer your questions than hear myself talk anytime, Judge. The other thing I would say is that absent a finding that Part 1, Article 32 contains an affirmative duty. Well, I want to talk about one other thing, the difference between positive and negative rights. Generally speaking, the Bill of Rights protects citizens from hostile actions by the government. It's the only instance in which I am aware that the Bill of Rights or the Constitution creates an affirmative right that requires the government to do something for somebody is in the court's construction in the Claremont cases of Part 2, Article 83. And that has been a controversial determination for going on 30 years now, because it's an affirmative obligation of the government to do a thing. The Bill of Rights is about protecting individuals from government action, not requiring government to take action to do a thing for a citizen that they want to have done. And Mr. Richard is asking you to, rather unprecedentedly, with the exception of the Claremont cases, find that government has an affirmative duty to him to do something with the paper that he wants to deliver to the legislature. And I would urge you not to do that, Your Honor.
Croc TV.